for today, Mr. Amila Sirivardhara, who is a lawyer specialized in civil litigation. He is also a senior lecturer and academic coordinator of Royal Institute, Colombo. We warmly welcome you, sir, and we are pleased to have you here with us today.
Thank you. It's a pleasure to be here.
Thank you, sir. Without further, I shall end this, ensuring you that this discussion will be a fruitful one. Thank you very much.
Thank you, Farah. So before we get into the topic, which is a very important topic today, I would like to brief you about today's program. It's Law is Life is a trilingual legal discussion where we look into different aspects of the law and we try to simplify the law for the general public. But please do keep in mind that this is just a guidance, and if you do have any issues, you need to contact an attorney at law for your relevant issues. With that being said, we'll well into the questions for today. Sir, could we start with how we categorize land in Sri Lanka?
Yes, so in a general sense, if we subject land into a broad categorization, I think we can mainly divide it into government-owned land or state-owned land and private-owned land. State-owned land will mainly refer to land that has been occupied by the state through various acts of parliament. It can be the land reform law or under the forest department or under relevant other acts of parliament, which will be held by the state. Looking at private-owned land, it's the land that people like you and I can own. So we can deal with such land freely as we please, subject to certain restrictions, of course.
Okay, sir. So according to law, how can state lands and private lands be alienated?
Yeah, actually, when it comes to private land, I think the law is much simpler, but we'll first focus on state-owned land. When we look at state-owned land, there are mainly three ways in which state-owned land can be alienated to private individuals. The first method we refer to as a permit. So government-owned land can be granted to individuals through a permit or through a grant. Sometimes we refer to this as a grant. And the third one is by the president. So there are certain laws where the president also can grant state-owned land to private individuals. If we are to look at a permit, usually a permit will be granted to individuals who have a low income or who doesn't own land. So usually these lands will be granted for a specific purpose, maybe cultivation or for residential use. But the thing about these permits or government permits is it will be subjected to strict conditions. So you can treat it's as opposed to a private ownership, there will be certain conditions where the landholder will have to abide by. If some of these conditions are violated, then the permit can be revoked by the government. When we look at grants, there are several grants that the government has issued up to date under various phases. Sometimes it's referred to as Swarna Bhumi land. Sometimes they call it Jaya Bhumi, Rana Bhumi, and Rana Bima, etc. So these are focusing on a specialized purpose of the government or the government that is running on the relevant time. They have come up with various concepts and they have issued land to various private individuals. But like a permit, even in a grant, it will be subjected to certain rules and conditions which the land possessor must abide by.
So you spoke of grant and permit. What is the difference between the two?
Yeah, so a permit will be issued mainly for cultivation purposes. It can be for coconut or to do a paddy field. It can be very rarely for residential purposes, but when we look at permits, it's usually issued by the Land Development Ordinance. We call them LDO lands. So, and these lands are managed by the Divisional Secretariat. So any transfer of ownership between the current owner and the other owner will have to be dealt through the Divisional Secretariat, as they have several forms that needs to be filled in order to comply with that. On the other hand, a grant, as I said, is for a special purpose where the government has promised certain properties to people under a heading. As I said, it can be referred to as Jaya Bhumi or Smarna Bhumi, where low-income people will be allowed to occupy a defined space of land and maybe build houses on it as well.
Okay, sir. And so land it's an asset to anyone out there, and I'm sure people will be interested in knowing how can land be passed on to another person, the process.
Yes. So when it comes to private owned land, I think most people would know that you transfer your land through a deed. That means it has to be executed by a notary. There are certain rules and regulations under the notary's ordinance that has to be fulfilled. But when you look at government permits or government grants, the general law of succession usually will not apply to such land. Why? Because just to give you an example, if you are the owner of a government permit and you happen to pass away, your interest doesn't devolve among your next of kin under the normal circumstances. What generally happens here is that your surviving spouse would gain a life interest, and therefore she or he will have to discuss with the divisional secretariat on how to convert that permit into a more permanent one. However, it is possible for permit holders to nominate their successor prior to any such situation that involves their death. So if it's always safe to nominate your next of kin, in which case once the permit holder passes away, the nominee can make an application to the divisional secretariat and obtain the permit hassle-free, I should say.
So you mentioned life interest. Could you simplify the term for the general public?
Yes, life interest means you have an interest to occupy and cultivate that particular land for as long as you live. But after you pass away, that interest doesn't materialize into a property interest and pass on to your next of kin. You can enjoy the land for as long as you live, but you do not have the right to pass it on to your children.
So that means it's not 100% ownership, but you can utilize land for your purposes.
No, it is not ownership.
Okay, sir. So could you tell us what a deed is and what purpose it serves?
Yes. Now, the whole purpose of a deed, I believe, is to provide evidence. Now, if I say that I'm going to transfer my land to you, Zina, for example, that would not mean anything unless you can prove that in a court of law. For example, if I say that I'm transferring my land, or I hereby transferred my land to you, that will have no effect in law because you're unable to prove that transaction. So if I later on go back on my word, you don't have any legal rights against me. So I believe the most important reason for executing a deed with regard to land transaction is that you can evidence this in court. So when you go to court, you have some sort of documentation to prove that a transaction with regard to this particular land has been executed. Having said that, I would like to also differentiate a deed and a general written agreement. Now, if I want to transfer my land, there are two options. I can write it in a piece of A4 paper and say, I hereby transfer my land to you, or I can execute a deed. Now, the thing about executing a deed compared to a written agreement is it's slightly complicated. Why? Because there are certain rules that we have to satisfy. We need a notary public to attest the document. We need to have witnesses, and then we have to have the executants to sign the deed. So there are certain requirements that we have to satisfy. But when you compare it with a written agreement, you can just get the parties to sign it and enter into the transaction. But the problem is this: if you are to prove this in court, if you submit a general agreement as far as the law is concerned, it will be treated as a mere piece of evidence. That means you need other evidence to support that agreement. But when it comes to executing a deed, you can prove the deed in a court of law mainly on the document, which means you don't need any other extra evidence or extraneous evidence to prove that a transaction has been executed. If I'm to keep it very simple, you can proceed in a court of law mainly based on the deed, and you don't need any other evidence to prove the transaction.
So for clarification purposes, can this agreement be verbal as well with, say, a couple of witnesses present in the room? Say a family agrees to pass on property and they verbally agree. Will that also be able to taken up in court, or do they really have to have a written agreement?
Well, if I'm to just give you a simple answer, the answer is no, because sections 2 and 3 of the Prevention of Frauds Ordinance clearly says if the transaction involves immovable property, it has to be evidenced in writing. So no oral arrangement can be used to evidence a transaction with regard to land.
Okay, so thank you for the clarification, sir. So the next question is, what is an effect of a deed and what are the types of deeds?
Yes. Now, I think I have already kind of covered the effect of a deed, right? I think most people don't understand the importance of a deed, mainly when it comes to lease agreements as well. Some people are inclined to enter into general agreements in order to avoid stamp duty and other, complications that, basically ensue with executing a deed. But I must remind the general public about the importance of executing a deed. As I said, a general agreement will be just one piece of evidence that you can submit in court, whereas a deed, it can be the sole document on which you can proceed the case and obtain relief from the relevant district court. So that is the major effect of the deed. You provide not only evidence, you also provide the main document on which you can pursue your rights. But when we look at the types of deeds, if I'm to put it in, again, we don't have enough time to go through all types of deeds, but I will discuss the main types of deeds. Now, one of the main types of deeds that we generally execute is referred to as a deed of transfer. A deed of transfer is where a purchaser is interested in buying the land. He pays the consideration or the amount that he wishes to pay to the seller, and the seller will execute this thing called a deed of transfer. The rules are the same. It has to be attested by a notary public. It has to be witnessed, but only the seller needs to sign the deed of transfer. The buyer is not required to sign a deed of transfer. But when you compare that with a deed of gift is where a person is gifting the land. So with the term gift itself, I think all of us understand that there is no consideration involved. We don't pay any money to the purchaser. So in those circumstances, the law dictates that it's necessary for the person who receives the gift. We refer to this person as a donee. So it's necessary for the person who receives the gift to also sign the instrument. So we need the donor and the donee to sign the instrument. Once again, it has to be attested by a notary public and witnessed. So the major difference between a deed of transfer and a deed of gift is consideration is a must in a deed of transfer, but obviously in a deed of gift, you need not pay consideration. And also there is a slight relief or concession, I should say, with regard to the payment of stamp duty. In general, it would be 4% of the purchase value for a deed of transfer, which you need to pay to the government, whereas in a deed of gift, it is 2%. So there's a 50% concession when it comes to a deed of gift. The third type of deed I would like to discuss is a deed of declaration. Now, a deed of declaration, I must say, is not as strong as a deed of transfer or a deed of gift. The whole point of a deed of declaration is where you have become entitled to land, but not through a deed of transfer or a deed of gift. So you have apparently acquired ownership through other means. Like what? For example, you can acquire ownership to someone's land under the law of prescription. What does that mean? The law of prescription refers to a scenario in English law, we call this adverse possession, where you have occupied someone else's land without permission for an uninterrupted period of 10 years. So if you can prove that you were in occupation of that land for an uninterrupted period of 10 years, what happens is, under the law, you may become entitled to prescriptive rights on that land. So the problem is, you don't have a deed, but you are entitled to that land. So let's say someday you're interested in selling this property to someone. Now, obviously, the purchaser will ask you, do you have a deed? So you have no way of explaining how you have come to own this land. In such circumstances, it's advisable for such parties to execute this thing called a deed of declaration. So a deed of declaration is simply where you explain in the deed as to how you came to own this land and for how long you have been in possession, and this, because of this reason, you are the new owner of this land. So it provides somewhat of a clear picture to the purchaser as to how you have come to own this land. Another scenario where a deed of declaration might be issued is where the owner of land or the former owner has passed away. If the former owner has passed away and you are the only surviving heir or next of kin, right? That means both parents are dead, and let's say, for example, X is the surviving child. So if X is the only surviving child, the child will be entitled to the land. But then again, once again, I should say, X does not have any way of proving that he or she is the new owner of the land. So once again, they will have to execute, or he or she will have to execute, a deed of declaration explaining the circumstances under which this person became entitled to the land. But I must say, the notary public executing this instrument does not know what happened in reality. For example, a client will come and tell us that they have been occupying that for the past 10 years. As a notary public, I would not know whether this person has done that. So that is why I said a deed of declaration is less persuasive compared to a deed of transfer or a deed of gift, because the notary public himself or herself cannot assure that the facts are accurate. So what we usually do is we get the party to sign an affidavit, basically stating that the facts in the declaration are true and correct. So those are the main three types of deeds.
So what happens if the original owner challenges it? Can they challenge it once the period has elapsed?
Of course. Now, prescriptive rights, once you have occupied the property for, as I said, an uninterrupted period of 10 years, you will become entitled to the land. Of course, majority of the time, the landowner, or I should call them the paper title owner, can challenge this in a district court. But as I said, when this goes to trial, if you can prove evidence from the neighbors, you have registered yourself at the with the Grama Sevaka, so on and so forth. If you can prove that you have been in occupation of this land for 10 years, then that paper title owner's right can be defeated. But the problem is, interested purchaser will be running a risk as to whether this person who is claiming to have prescriptive rights, whether this person actually has such rights. So that is a risk that the purchaser has to run.
So in the event there is a forgery committed, a deed is forged, so then what steps can a person take in order to clarify whether this deed is legitimate?
Okay, so to simplify that answer, if a deed is forged, for example, if a seller, let's talk about a deed of transfer or a deed of gift. If a person has either sold the land to you through a deed of transfer or gifted the land to you, but the person who has done so is not the legitimate owner. Let's say it's a sale transaction. So I have requested for documents. This person produces documents which prove that the seller is the owner. But in fact, those documents are forged. It happens. It can happen. So in those circumstances, what is the purchaser situation. I think that's what you're asking. If I buy land and if the documents are forged, what would happen to me? Well, you would notice in every deed, there is a clause where the seller will warranty, or I should say guarantee, that he or she has proper title to this land. So when a person signs a deed of transfer, they're not just saying, I'm selling my land to you. I'm also providing a guarantee there is nothing that will happen in the future that can challenge my right to sell this land. Right? In Latin, there's a phrase, I don't want to use that phrase in this discussion because we're trying to keep things simple. But if I'm to use the English translation of that statement, you cannot give another what you yourself do not own. So if a person has forged documents, clearly this person cannot give ownership to the purchaser. But what the purchaser can do is sue the seller, the so-called seller, for forging the documents because he or she has violated that clause in the transfer deed which guarantees good title. So unfortunately, you might not get the land, but you will be entitled to compensation from the person who forged the documents.
Okay, sir. Thank you for the lengthy explanation. Moving on, sir. Is it mandatory to register the deeds at the land registry?
Well, simple answer, no. There's a common misconception among people. They think that once a deed is executed, it is mandatory to register it, otherwise the deed is useless. This is not true. The moment a deed is executed, all rights that you are entitled to will be given to you through the deed. That has to be said, right? But what is the purpose of registration? The purpose of registration is to gain priority. What does that mean? For example, if a person sells the land to you, right, and you decide not to register this deed, but subsequently the seller sells the land to someone else as well. Did you get it? Two deeds have been executed on the same land. This is that forgery kind of thing. Two deeds have been executed on the same land to two different purchasers. Now, if the second purchaser goes and registers his or her deed at the land registry, and subsequently you get to know that someone else is trying to occupy your land and you end up going to court, the court will give preferential treatment to the person who registered the deed first. That is called priority, because that person will be given a better position compared to you. So the major reason for registration is to gain priority over any other people who might subsequently register their interest on your land.
So could you clarify as to what would constitute a valid deed as well? Are there elements to the document that need to be satisfied?
There are quite a few elements that needs to be complied with. In fact, it's under the duties of a notary in section 31 of the notary's ordinance. So there are quite a few duties that a notary has to comply with, but if I'm to keep things simple, when executing a deed, it has to be printed on certain durable paper. So the deed itself has to be printed on durable paper. You need to witness it, and either the witnesses or the people who are executing the deed should be known by the notary. Got it? And the notary has to verify the situation of the land. The notary has to give an account of the accuracy of the contents of the deed. Now, this is where I said the notary will struggle in a deed of declaration. But when it comes to a deed of transfer or a deed of gift, the notaries are expected to carry out a proper land search at the land registry and also call for title documents. So if I'm to just go by the requirements for a valid deed, as I said, you have to print it on durable paper. You need to have witnesses. The executants have to sign. The notary public himself or herself has to sign it as well. And most importantly, all parties have to be present at the same time in the presence of one another.
Okay, sir. And so maybe some of the viewers who are like first-time purchasers of land might be interested as to what will be the time period that will take for the entire process. So could you explain that as well?
Entire process for registering
for a first-time purchaser of land. to check
okay.
the deeds?
Yes,
Yeah.
yes. Yeah, so when purchasing land, I think the main thing that we generally look for is title. Yes, we have to first and foremost see whether the seller is the rightful owner of the land. Now, how do we check this? We usually adopt quite a few techniques. The first thing is we'll call for the title deeds. Obviously, if Zinath, you're claiming to be an owner of land, you have to be able to produce a deed. This can be a deed of transfer or a deed of gift. But if you happen to produce a deed of declaration, I might be a bit scared, as you know, because we can't really verify the truth. So generally, we advise clients against it when we see a deed of declaration. However, if it is a deed of transfer, a deed of gift, the next step that we carry out is we go to the land registry and we carry out a search and see whether the documents have been registered. Correct? So actually I should say the correct practice is to call for deeds for the past 30 years. We go and check for title for the past 30 years and see whether there is a clear chain of title. By chain of title, I mean, has it come from A to B, B to C, B to D, and from D to U, for example. Right? We need to see whether there is a break in the chain. The easiest way to check the chain of title instead of just calling for deeds one by one is to conduct a search at the land registry. The land registry generally, because as a general practice, we register all documents, all transactions at the land registry. So it's much easier to conduct a search at the land registry and obtain clear title and see whether there are any issues, especially to see whether the land has been mortgaged or promised to someone else. So if we are happy with the chain of title, then we move on to other things, like we see whether the land has been vested in the government or the municipal council. Sometimes if you don't pay your relevant tax, the government or the local authority has the authority to vest the land or acquire your land for non-payment of tax. So we have to go to the relevant municipality or the Pradeshia Sabha and get a document where they guarantee that the relevant tax has been paid up to date and there is no problem whatsoever. And the third thing we look at is obviously the plan and see whether the plan has been approved by the relevant municipality as well, because if it's not approved, some people do go ahead and purchase it, but they can face problems later. So we see whether the land has been, we look at the street line, that is to see whether how much of the land you have to give up in the event the government decides to expand the roadways. So those are also important factors when looking at the plan. And if you're buying a land with a house, then of course we will look for approved building plans and what we call in short a COC, certificate of conformity, where the local authority has approved the construction and there are no problems whatsoever. So if all the documents checks out, what we do is we will give a thumbs up to the purchaser to go ahead with the transaction.
So could you explain what a contract of sale is and the requirement for such a contract?
Okay, so again, I think I will perhaps overlap on something that I have mentioned earlier as well. A contract of sale is not a transfer. I think that's the first thing I have to say. A deed of transfer is where immediately when I sign the deed, my rights have been alienated to you or someone else. A contract for sale is a promise. It's where I promise to sell my land to you. Okay. Now, usually when a promise is made, it will entail certain conditions. For example, that means you have to fulfill certain requirements that are to be done in the future. I'll give you an example. So I'm interested in buying your land, but the relevant plans haven't been approved. If the relevant plans haven't been approved, I'll say, Zinath, I'll buy your land, but we'll enter into a contract for sale. I'll promise to buy your land, provided you obtain the necessary approvals. Once you obtain the necessary approvals within a given period of time, this can be 3 months, 6 months, 1 year, doesn't matter. And after that, we will execute the deed of transfer. So a contract of sale, as I said before, is a promise to buy the land, provided certain conditions are fulfilled. Now, another question you asked me is, what are the requirements? A contract for the sale of land also, Zina, can be entered into by a mere written document, or you can get a notary to execute it. Again, I don't need to harp on the importance of a document that has been executed by a notary. So more often than not, we get a notary to execute a contract of sale. Why? Because that will enable you to register this document at the land registry. The purpose of registration, I told you a few minutes ago, is priority. But in addition to that, you provide notice to the world of large that you are interested in purchasing this, or this land has been promised to you. Purpose is priority, but secondary purpose, as you asked me about contract for sale, you give a notice to the world at large saying this land has been promised to me, so you need not be interested in it. So we are trying to use the registration as a I guess make the land less attractive to other purchasers, because they know that the land has been promised to someone else.
So can this contract of sale be verbal? And also, like in the event, the buyer says that, okay, I will give you 80% of the payment and I'll give you 20% after, say, 6 months. Can that be a verbal agreement? And say he pays that 80% and they already signed the documents, the relevant documents. So does the ownership pass at that point, or does it pass after the 100% payment?
Okay. So one thing needs to be clear. Oral agreements are inadmissible in court unless we are going on the basis of a trust. Now, trust law has its own mechanism on how it works. So I don't want to touch on that because that might, complicate our discussion. So just to keep things simple, as I think I mentioned, according to the Prevention of Frauds Ordinance, any transaction with regard to immovable property has to be put in writing. So any oral arrangements between the parties will not be admitted in court. I mean, you can try, but the judge is not going to take any cognizance of what the parties have entered into orally. Got it? So it's very important, I should say, that parties enter into a written agreement, preferably execute a deed. And one thing is for sure, ownership will not pass just because you enter into a contract for sale. A deed of transfer or a deed of gift has to be executed in favor of the person acquiring the land. Otherwise, ownership will definitely not pass.
Okay, so in terms of the 80% payment, if the deed also has been signed, in that scenario.
Oh, okay. So your question is, the deed of transfer has been executed, but yes, the payment hasn't been made.
Not 100%, just 80%.
Okay. So if now, when we execute a deed of transfer, it's generally executed by a notary. The notary will attest this document. Now, what are the requirements in attestation? The notary has to mention who the executants are. He or she will say who the seller is, how the seller has signed it. Is it in English? Is it in Sinhala? Is it illegibly? So all this will be explained. Who are the witnesses? Are they known to me or known to the notary? How have they signed? Did you get it? All these details are there. Most importantly, in a deed of transfer, the notary will also mention how the consideration has passed. So, for example, if 80% of the monies were paid, let's say I'm the notary, if 80% of monies have been paid before me, what I would say in my attestation is this amount has been paid and the balance have been promised. So, based on that, you may have an action to recover the balance. But generally, what we advise our clients is get the full payment at the time of executing the deed of transfer. Just to answer your question, I think you asked me if I pay 80%, will the ownership pass? Answer is yes, because the moment you execute the deed of transfer, the ownership has passed. So there's no way you can recover the land. All that you can do is recover the money. So best option is to get the full payment first up the moment you sign it, or don't sign it. If you're not going to get the full payment, better you enter into a contract of sale. where you promise to execute a deed of transfer once the full payment is made. Or a second less attractive option, but some people do that, I don't advise in favor of it, is that people get a check, a post-dated check for the balance, so that they can maintain a different action if the amount is not paid or the check is dishonored. Yeah.
Thank you, sir, for the detailed explanation on that. So could you tell us what are the rights an individual can gain through ownership?
Yeah. So I think ownership is the best right that a person can be entitled to in land. It's the best title that you can have. What do I mean by that? You can enter into various transactions with that land. You can lease it out for a very long period or a short period, up to you. You can grant license agreements. You can have, basically what I'm trying to say is you can enter into any particular transaction. If you want to gift it, you can do that. If you want to sell it, you can do that. So as I said, the best title that a private individual can have in land is ownership, because they can enter into various transactions with regard to that land and no one can challenge their right.
Okay, sir. So could you tell us the difference between ownership, possession of land, and title?
That's an interesting question. Ownership. I think we can couple the term title and ownership. Usually title, when we use the term title, we refer to ownership, right? We say, does that person have ownership? Or we can sometimes use the word interchangeably. We say, does this person have title? So I think the words title and ownership refer to the same thing, where you have some document which you can prove, or where you can prove that the person is entitled to that land. The best proof is a deed of transfer. But let me talk about possession. Now that's why I said it's an interesting question. Now, usually with ownership, we do have the right to possess the land. But this is not always the case. Sometimes there might be someone who is possessing your land, but you are the owner. For example, remember prescription, a person can go and occupy your land without your permission. Let's say you were abroad for a few years, you come back to Sri Lanka and you get to know that some random person is occupying your land. Now, in these circumstances, we can't use violence and try to evict this person, because there are possessory rights that people are entitled to under the law of Sri Lanka. So the best thing you can do is, remember, for prescription, possession has to be uninterrupted for 10 years. So if this person has only been in occupation for 5 or 6 years, you can interrupt that possession. Interrupt means not physically try to put this person out. As I said, we do not resort to violence, but what you can do is you can file an action in court. If you file an action in court, this person's possession is interrupted. So you will have to go through, unfortunately, the tiresome process of litigating and acquire your possession. So just to keep this answer short, ownership and possession usually come together. When you own land, you do have possession, but it can be a scenario where someone else is occupying your land. So this person has possessory rights, you have ownership. So you will have to file an action in court and get the person evicted from the property so that you can regain your possession. Another situation where your ownership and possession will be demarcated is if you grant a lease over your land.
Hi again, sorry for the interruption. We will continue with the rest of the questions. Farah will continue with the questions. Over to you, Farah.
Thank you, Zainab. We had a slight interruption, yeah. Sir, my next question is, how is a deed transferred post someone's death? Once, if someone dies, how it will be transferred, if there is a deed or if there is no deed present as well?
Yeah, so when a person dies, there are two ways in which this person's property will devolve. The first way is where a person has written a last will. If a person has written a last will, then that last will after the person's death can be proved in a district court, and to whomever properties have been donated, we use the word bequeath. So to whomever the properties have been bequeathed will receive it according to the last will. So you can give it to your children or your spouse or even a random third party. You can devolve your property through a last will. We call this testate succession. But if a person happens to pass away without executing a last will, then we call it intestate succession. Then the person's property rights will be devolved according to the matrimonial rights and inheritance ordinance. So according to that, the spouse and the children will get a specified share.
Thank you, sir. My next question is, sir, what are other rights available over one's own land? Apart from the rights we discussed, what are the other rights available?
Yeah, so the other rights, as I said, so the rights we have discussed would be your ownership, or if you're a tenant, you would have possession rights and so on. So other rights that people can claim are rights such as, I think I explained this sometime a few minutes back, I guess, life interest. A person can have life interest. So the person doesn't have ownership or a lease or anything of that sorts, but the person has the right to occupy the land for the duration of his or her lifetime. Right? Another right that a person might have over one's land are servitude rights. This is like a walk path or a driveway, or the right to use your neighbor's well or to park your vehicle. So these are temporary rights that you may have over someone else's land. So we have things like life interest, we have servitude rights, which can be a variety of servitudes. In English law, we call them easements, like a right of way, as I said, and so on. So those are some other categories of rights that we can have over land, which are not necessarily entailed with the right of ownership.
Thank you, sir. The last question for the day, sir, is if there is no last will, what will happen to that property? How can that property be divided among the family members?
That's a good question. Most people only know this to a certain extent. So if a person hasn't executed a last will, that means, as I referred to it before, it's a intestate succession. That means you haven't mentioned to whom you want to give your property to. So according to section 23, if I'm not mistaken, of the Matrimonial Rights and Inheritance Ordinance, the order of devolving property in an intestate matter will be as follows. It will be descendants, that means your children. If you don't have children, it will go to your ascendants. We call them the deceased parents. And if the parents are also not alive, we refer to them as collaterals. That means the siblings of your parents. So it will be the deceased aunts and uncles. So generally speaking, if a person has died without a last will and this person is married, half of the properties will go to the spouse and the other half will go to the children. But let's say they didn't have children. If they didn't have children, the balance half will go to the deceased mother and father. So the mother gets 1/4 and the father will get 1/4. But if the mother or father happens to pass away, their respective share will be divided among their brothers and sisters. So technically speaking, the deceased aunts and uncles.
So if I may ask a follow-up question to that, in the event a person has two families, how would that work because they'll be and have children from two different families under the general law?
It's a good question. Under the general law, if a person has children for, let's say, 2 wives or 2 husbands, then in those circumstances, the first thing we have to know is whether the marriages were legal. Because if the children are illegitimate, then one thing is for sure, illegitimate children cannot inherit from the father. So if the father happens to pass away, they will not inherit under the normal inheritance law. But they can inherit from the mother. So that's one thing that you have to note. The second thing is, if both marriages have been legally consummated, that means he was married, he or she was married, they had children,
now properly divorced and married again. So if in those circumstances, then children in both marriages are legal, legitimate children. In those circumstances, the law will be the same. For example, if the person happens to die or passes away, half of his properties will go to the current spouse, obviously, to the person you were married to at the time you passed away. And the balance half will be equally divided among the children, regardless of whether the children came from the previous marriage or the subsequent marriage.
Right. Thank you so much. So that was very elaborating on how, because since this is a trilingual legal discussion to educate the public, there are so many questions about land law which the public doesn't know. And we thank you, sir, for joining us today and helping us solve the matters of the public where they have so much doubts about, especially when it comes to land law. We have come to the end of this discussion. And once again, sir, I thank you so much for giving us such a fruitful discussion on this topic. And we also thank everyone who joined us today and made this a success. Thank you very much.
Thank you.